Hello and welcome back. Today we continue our discussion on the European labour mobility policy with an emphasis on residence rights and the posting of workers. We focus on how implementation of these policies is organized in the member states, who is responsible and who coordinates policy making. I want to welcome our local experts, which you already met in the previous video. Welcome to Marcia Zwart of the Dutch Labour Union FNV in the Netherlands, Petru Dandea of the Romanian Labour Union, Cartel Alpha in Bucharest, Romania, and Anthony Valka from the University of Kent in the UK and Versailles College in Brussels, Belgium. Let's start. How is the implementation organized in different member states?
Member states get to choose which authority gets to apply the rules in line with their constitutional framework, and this is discretion that they enjoy under Article 288 of the Treaty on the Functioning of the EU, which provides that member states have a choice as to the means and ways of implementing directives. And so the authority which is tasked with applying the rules will depend on the country concerned. And we can distinguish some differences between centralized and decentralized application of the rules. So countries that have a unitary centralized government, such as the United Kingdom, you have one authority, the Home Office, and specifically its division called the UK Visas and Immigration, which gets to apply the rules for the entire United Kingdom. So when EU citizens and their family members come to the UK, it's that authority which has the sole power to apply the rules. You can distinguish that from countries that have a more decentralized approach to decision making, such as, for example, France, where it's at the level of the préfecture that the decisions about residence rights are made. And countries like Belgium and Italy, where municipalities make the decision, they are the ones who apply the rules. Although it's interesting that there are also within decentralized countries that have decentralized frameworks, there are differences. So again, if we go back to the example of Belgium and Italy, the rules are slightly different. The way that the rules are applied is slightly different because even though both have municipalities, it is distinct organizations, entities that make the decision. So complex decisions in Belgium will be sent by the municipal authorities to the centralized immigration office that makes a decision on complex decisions. Examples are, for example, where an EU citizen claims a right of residence because they don't work, but they have sufficient resources not to be a burden on public assistance. And the source of those resources it may be a parent or a partner. In those cases, the Belgian authorities consider these complex cases, and the decision will be made by the immigration office. So the application will be made at the municipality level, but the final decision will be made by the centralized immigration office. We can contrast that with another country that has this decentralized framework, like Italy, where the decisions will be made at the decentralized level, but the different entities will be responsible based on the nationality of the person. So EU citizens will apply at the municipality, but non-EU family members will apply at the questura, which is the local police headquarters. So we can see that even within decentralized countries, there are differences in how the rules are applied in practice.
Well, I'm very curious how, let's say, in these decentralized systems, these organizations basically coordinate the distribution of tasks. How does this work?
Well, of course, the national constitutional framework will play quite a part in that. But where the countries where there is a decentralized or federal structure, the entities, the state entities which operate at the federal or centralized level will, for the most part, be involved in providing direction to the municipal or decentralized or federated entities as to how the rules should be applied. So, of course, the federal government or the central government will be the ones involved in drafting and adopting the legislation. They will then also adopt guidelines or ministerial circulars that provide guidance and direction as to how the municipal and federated authorities should apply the rules in practice. So there is a division, of course, of labour depending on the internal constitutional setup of that particular country.
Who is overseeing implementation? Do we know how many applicants are there and how decisions were made, and who is noticing when there are mistakes made in applying these rather complex rules on residents?
Well, unfortunately, the directive does not contain any obligation on the member states to collate statistics about how the rules are applied in practice. So it's left to the member states' discretion as to which countries collate statistics. And there is a wide variation in terms of the details of these statistics. Unfortunately, we only have, as far as I've been able to determine, 4 countries, for example, that collate statistics about the expulsion of European citizens and their family members. But unfortunately, we have little, although we have those statistics in only 4 member states out of 28 member states, those 4 member states provide little information about the reasons why EU citizens and their family members have been expelled. Also, we are in a paradoxical situation where we actually have a better idea about the situation of non-EU citizens, non-EU nationals living in the EU than we do about EU citizens and their family members. And that's because the EU adopted a regulation in 2007, that's Regulation 862 of 2007, on the collation of statistics for immigration purposes. And that regulation imposes detailed conditions and an obligation to contain detailed statistics on the migration of non-EU nationals, but there's no obligation to collate similar statistics for EU citizens. So as a result, we have a better idea of the situation of migration of non-EU citizens than EU citizens themselves, which of course makes monitoring quite difficult.
What happens if a deviation from the rule is noted? And I guess in this case, in the case of the residence directive, it will be mostly by applicants themselves.
Under the directive, it's the national courts who are there to arbitrate, to decide disputes between citizens who feel that their rights have been infringed by the national administrative authorities and that their rights under the Residence Directive have been breached. So it's the national courts who will, in national appeal procedures, who will decide whether a particular individual's rights have been breached on the directive. And it's interesting there that although the national courts have to provide for appeals, that there are quite significant differences, of course, in how those appeals operate in practice. Under general principle of European law, it's for the member states to decide what national procedures apply to proceedings in the national courts. And we can see that there's quite a lot of variation between the member states. So countries like Italy and the United Kingdom, there the courts have the power to remake the decisions of the national authorities if the courts decide that those decisions were wrong. So they can substitute themselves in the place of the national administrative authorities and remake the decision from scratch. You can contrast that with the situation in countries like Belgium and France, where there are more limits on the scope of the judicial review that the courts can engage in. And there, the control, their control is limited to a control of legality to determine whether rules were followed, and also to determine if the decision of the national administrative authority was proportionate. And we can see that, for example, in Belgium, that control of legality is quite restrictively interpreted. For example, the directive prohibits member states from the possibility of expelling EU citizens when they work, except in limited circumstances where they might have committed a criminal offence or they might have engaged in conduct which goes against national security. But in the absence of such conduct, the member states cannot expel workers. And we see that in Belgium, what happens is that often the national authorities will make a decision where they withdraw the right of residence of an EU citizen because they feel that this person has been unemployed for a lengthy period of time, and they come to the conclusion that this person will not be able to find a job in Belgium. So they issue a decision which withdraws the right of residence and which expels them from the Belgian territory. And it is often the practice of the immigration office to delay in serving, in notifying this decision to the individual. And often what happens is that during this delay, which can be months, and we've even seen years in some instances, during this delay between the time that the decision is made and the time that the decision is notified to the individual concerned, that person might have found a job. And as a result, the Belgian authorities are in effect expelling workers, which is prohibited under the directive. And the courts, when this issue is, the Belgian courts, when this issue is presented to them, have said that this procedure is perfectly acceptable because as a court, they decide on the legality of the decision at the time it was made and not at the time when the hearing into the appeal is held. And of course, that means that creates problems. And that approach of the Belgian courts seems to be in breach of the Court of Justice's rulings, particularly in the case of Orphanopoulos, where the court said that if, when a decision to expel an EU citizen is made, new facts come to light which question the ability of the national authorities to expel that person, that those new facts should be presented and heard by the national court. So we have a situation where, even though the Residence Directive provides for a right of appeal, there's different ways in the way in which the member states implement that right of appeal in practice, and we see that in Belgium it's very restrictive.
How is now the implementation of this policy organized in Romania? Is it centrally organized, or are there also decentralized components?
Speaking about posting, if we are discussing about the regulation, the European regulation 883, we have, let's say, a mixed kind of implementation, because we have national institutions, but also local institutions which are responsible for the implementation of 883. Discussing only about posting is very highly centralized policy, because on posting of workers, only national institutions like National House for Pensions and the National Labor Inspectorate are in charge with this policy in Romania. So any company which intends to have posted workers abroad apply only to these two institutions when at the time they wish to work on a commercial contract with a foreign company and needs to post workers outside Romania.
You already explained that there are several organizations involved in the implementation of this policy. Could you briefly explain which organizations these are and what their responsibility is?
Yes, there's 4 players in the field. There is the SVB, what we call Sociale Verzekeringsbank, who registers A1 forms and who issues out A1 forms. That's all they do. Then we have the tax office, who is there to monitor that all companies, whether Dutch or foreign, pay taxes. They are very good at this, at telling everybody how much taxes they have to pay. What the tax office doesn't do is check if the income over which taxes are paid is correct. That's the task of the Labor Inspectorate, which is in the Department of Social Affairs. And the Labor Inspectorate makes sure that every company pays their workers, whether foreign or Dutch, at least the Dutch minimum wage. Then the complicated thing in the Netherlands is that the Dutch minimum wage does not apply to 95% of the people working here. We have collective labor agreements, legally binding collective labor agreements, which apply to 95% of the population. And that extra 30% income between the minimum wage and the collective labor agreement is actually monitored by employers and unions, as the one that I work for. So we have 4 players in this field.
That sounds very complex. So my question would be, well, is there any coordination between those players? Are they connected to the same ministry, for example? That, of course, refers to the 3 implementing organizations.
I wish they were, but no, of course, that would be too simple. Would make life more easy, but no. Of course, there's the private sector, that's employers and unions. It's private. Then we have the Department of Finance, where the tax office is placed, and we have the Department of Social Affairs, where as well the Sociale Verzekeringsbank, the A1 institution, as well as the Inspectorate of Labor Affairs is placed. And what you see in practice is that if you get these parties at one table, that there's always a discussion on which information can I share with you and what can I not share with you. Not just between the private sector, the unions, and the government, but also between the tax office and labor inspector. You see, there's always a discussion. It's not an automatic thing to do checks and controls together, which is very odd, actually.
How is the task distributed between those 2 authorities? Who is doing what? You mentioned the Labor Inspectorate, you mentioned the House for Pensions. What is the role?
The role of the National Pension House is to release the A1 form. The role of the Labor Inspection, it is to inform the Labor Inspectorate in the country that posted workers are going about the fact that they are posted there, the company in which they are going to work, and other conditions related to their labor contract in the period of posting at the company on which they are going to work as posted workers. So these 2 institutions, first, National Pension House, which are releasing the A1 form. Secondly, the Labor Inspectorate, which is in charge with keeping the contact with the National Labor Inspectorate in the country where the posted workers are going.
Is there still some coordination taking place from the ministry, from the central government towards these 2 actors?
No. In fact, the Ministry of Labor in Romania, it is the central authority which is in charge for the coordination of these 2 institutions, National Pension House and Labor Inspection. So in a way, they are, let's say, subordinated to the Ministry of Labor, and via the Ministry of Labor to the central government. But the central government and the Ministry of Labor don't have, let's say, direct attributions in the implementation of the Posted Workers Directive.
If someone, and this seems to happen once in a while, if another member state, EU member state, for example, notices that they feel that the issuing of a A1 form might not have been done on the basis of the criteria which they think should be used, To whom do they complain, and who is then responsible in dealing with that complaint from another EU member state?
In Romania, the institution responsible for this topic is labor inspection. If such a complaint exists, labor inspection, it is responsible for, let's say, take this on board and offer a solution to the problem.
Who is responsible for checking whether posted workers stay only for 2 years in the Netherlands?
It's an excellent question. That's really an excellent question. In theory, there would be the issuing authorities in Romania and in the Netherlands or in Portugal. The one that issues the A1 is responsible for the monitoring. The funny thing is that if you have a Europe with all the different languages, can you imagine a Romanian A1 issuing authority coming to my town, 1,000 kilometers away, and see if the person who is working here is still working? 6, 7 companies later, because the companies keep changing. You go from company A to company B, you go home for 3 months on vacation without pay, and you come back with a new A1 form. The thing is, the real controls on the A1 are almost impossible because it's the homeland who has to control in the workland. In another language area, in a field where they cannot even come, the Romanian inspector doesn't come here to control, to check. So this is the problem. There is almost no monitoring.
But who is now responsible in the Netherlands for enforcing the posting directive? Who is checking here?
On the A1, that would be the Sociale Verzekeringsbank, who has very little personnel to control on the A1s. It's something they do on the side. That their main field of expertise is basically our pensions and our child benefits. So there's almost nobody in that office to control, to check. It's more a registration office. The inspectorate, the labor inspectorate, says it's not their field, so they are not responsible, and the tax office isn't responsible either. So you could say that despite the implementation in law of the Posting Workers Directive, which is good, the A1 is almost not monitored at all.